Chapter 14, Part 3. Okay, remedies of the seller or lessor. This is when the buyer or lessee has breached. The seller has various remedies depending upon the circumstances. They can sue for damages, and you can check your textbook for other remedies. We're not going to go into any depth on that issue. The right to cover. This is a situation where it's the seller or the lessor that is breached. In that situation, the buyer can cover. Cover means to purchase the goods elsewhere and then seek damages from the seller or lessor for the difference in what you had to pay for the goods from the third person as opposed to what you would have paid to the seller or lessor. When the seller or lessor refuses to deliver the goods, the buyer or lessee can replevy the goods, that is, get sued to obtain the goods held by a third party. As long as the goods have been identified and the contract has been repudiated or breached. And the buyer also can recover damages in that situation. And these are the measure of damages that you see on the screen. Okay, now moving on to warranties. How are warranties dealt with by the Uniform Commercial Code, Title II and Title II-A? What is a warranty? It's an assurance or guarantee by the seller or lessor of certain facts concerning the goods being sold or leased. The Uniform Commercial Code has numerous rules regarding warranties in sales and lease contracts. We're going to talk about a few of those. One is a warranty of title. That is that that there's good title. That is that the seller owns the property and has the right to sell it. That there's no liens on the property, and that no infringements will arise as a result of it. So basically, that the seller has good title and has the right to transfer the title to the buyer. No liens, as we said, not subject to a security interest held by somebody else. Infringements, we mean that there's no issues with regard to copyright, trademark, or patent claims that on the goods that are being transferred from the seller or lessor to the lessee or buyer. Okay, so the warranties cover all of that. Now we have what's called an express warranty. An express warranty is the seller or lessor's oral or written promise that's ancillary to the underlying sales or lease agreement regarding the goods' quality, description, or performance. For an express warranty to reach the right of a breach of that warranty, it has to be the basis of the bargain. That is, it has to be something that was bargained for. You don't have to use words like warranty. It is only necessary that a reasonable buyer or lessee would regard that representation as being part of the basis of the bargain. Here we go with opinion and value again, just like we talked about with contracts under common law. Only statements of fact create express warranties. Statements of opinion by experts also would be covered by a warranty, but not other expressions of opinion. An implied warranty differs from an express warranty. It's one that is based upon an inference from the nature of the transaction and or the relative circumstances of the situation of the parties. Some goods contain what's called an implied warranty of merchantability. Every sale or lease of goods made by a merchant who deals in goods of the kind sold or leased automatically give rise to this warranty of merchantability. Notice it's limited to a merchant. So sales between two individuals are not going to be covered by an implied warranty of merchantability. The merchantability warranty is that the goods must be reasonably fit for the ordinary purposes for which that type of good is used. That the goods are at least of average, fair, or medium grade, that they're adequately packaged and labeled, and that they conform to the promises on the label. The warranty of merchantability can be breached even if the merchant did not know or could not have discovered that a product was defective. We also have what's called a warranty for fitness for a particular purpose. This arises in the sale or lease of goods when a seller or lessee, a seller or lessor knows both of the following. Number one, the particular purpose for which the buyer or lessee will use the goods, that the buyer or lessee is relying on the skill and judgment of the seller or lessor to select suitable goods. For example, you go into a farm supply place to buy a lawnmower or something similar to that. You tell the salesman that you don't want a regular lawnmower, that you are going to be cutting down some very high things that are like grass but are thicker, heavier, and you show him pictures of what you're going to cut. He then shows you a machine that he says will do that job. That is a warranty of fitness for a particular purpose. So the seller knows the purpose and the buyer is relying on it. What about disclaimers of warranties? A seller or lessor can disclaim all oral express warranties by a written disclaimer included in the contract. The disclaimer has to be in language that is clear and conspicuous and must be called to the buyer's or lessee's attention. This allows the seller or lessor to avoid false allegations that oral warranties were made. This has to take place at the time the contract is formed in order for it to be a valid disclaimer. The way you can do this under most circumstances by saying that the sale is as is or with all faults. To disclaim an implied warranty, the seller must use the words merchantability. It doesn't have to be written, but if it is, the writing has to be conspicuous. However, if it's an implied warranty for fitness for a particular purpose, the disclaimer has to be in writing and must be conspicuous. Okay, the next topic has to do with international sales contracts between firms or individuals. Those can be governed by something called the CISG, or the 1980 United Nations Convention on Contracts for the International Sale of Goods. This convention basically follows a lot of the UCC rules, and it governs contracts from parties in the nations that have ratified the CISG. As of 2018, 84 nations have adopted the CISG. But it doesn't apply to consumer contracts at all, unlike the UCC. And it doesn't apply to contracts for services, as with the UCC also does not apply to services. So parties must take special care when drafting international sales contracts in order to avoid problems caused by distance, including language differences and differences in national laws. Items such as choice of language clauses will designate the official language of the contract interpretation in case of disputes. If the CISG and the UCC are in conflict, the CISG applies. The UCC does away with the